We have a special guest speaker today, Marc Haskelson, and he's going to be walking us through some pretty interesting HIPAA issues, including even how companies like Disney use things like HIPAA in improving their customer service experience and their brand awareness. And so, since we always try and keep our webinars short and sweet and informative, I'm not going to waste any time here. Any questions, go ahead and send them through the chat like you often do. Any very involved HIPAA questions or issues that you might have, anything with regard to compliancy, obviously we'll be providing you with information to contact Marc directly, and or you can always shoot us an email and we'll put you in touch or give whatever resources we have available. Without any further ado, Marc, let's go ahead and have you take over.
Okay. Today, what I want to do is spend a little bit of time talking about why you want to be compliant, big misunderstandings, benefits of being compliant, some basics, and then some very common sense do's and don'ts. Whether you're a standalone medical practice or a large hospital, a lot of these things are common sense things that have to do with people. So, from a carrot versus a stick perspective, it is a law. You have to do it. Doing it, though, can have a very profound effect, both positive and negative, if you do HIPAA compliance correctly. Okay? So a lot of that has to do with, you see it in the news, you see lots of different articles about what's going on, whether it's on the latest TV station or you see it in papers, and the issues of either cybersecurity, of people's information being hacked, or the dramatic somebody famous having their information accessed. Now, what I find kind of interesting is when I'm in a room and I start asking people about, do you play lotto? Okay, are you afraid to swim in the open ocean? Do you run inside when it rains? You play golf every week and play hole-in-one. So you do all of these things superstitiously because you think you have a chance of winning. Yet when it comes to the chances of you being audited, whether it's OCR, that's a HIPAA audit, or meaningful use, MAC or MIPS, your chances are 1 in 1,000. So you are, in today's world, rolling a dice. All right. The question is not if you will be audited. The question is when you will be audited. Will you be ready? All right. Now, so when without getting too deep on the negative side, there is something called the HHS Wall of Shame. That is the governing body of HIPAA. It stores breaches and incidences back for 24 months. This particular one just happens to be a group for eye care. And what you'll see is there's 18 or 19 of these just in the last 24 months where there was a major incident that occurred. And by the way, the Wall of Shame is something that's public. So you can grab it anytime you want and know that other people, as in your patients, and your, let's call it your competitors, also can go see that. So the breach information, to summarize it, what you'll find is the biggest issue that you have in regards to HIPAA violation, the two biggest issues, are not this big fear of ransomware and hacking. It's actually much more along simple human error about theft or loss, or the mistaken belief that often people believe that their partners, their HIPAA compliant hosting service, their EHR, their IT vendor is protecting them. Now, often they are, but do understand that in the world of violations, 30% of the violations or incidences that occur actually happen by the nature of the vendor that was serving you caused the problem. Okay, so real quick little game I play. If we were in a live room, this would be more fun. I would say, okay, are you HIPAA compliant? So if I was turn around and say, most folks, when I ask them if they're HIPAA compliant, they're very proud to say they've done a security risk assessment. Okay, usually by an external IT group. The next thing they say is we have policies and procedures. They have a manual. Maybe they paid a lawyer for them. Maybe they received them from their insurance company. Maybe they received them from their trade association. And then there's workforce training. Now, unfortunately, if these are the three things you're doing, you're not HIPAA compliant. Okay, is one of the big misunderstandings. And a real world example of this was a nonprofit behavioral health group in Alaska. Small fine, $150,000. Why? Minor malware. That's a email virus or ransomware, for example. The reason why they were fined was not for the incident. It was because when the government said, did you do your audits? They'd only done one of the required, a security risk assessment, not all 6 that are required. They did have policies and procedures, but they didn't properly, they were store-bought. Not that that's wrong, but you must take the time to make sure they accurately reflect your organization. And then last thing on the training, a lot of different ways to do what's training, and I'll talk more about what's effective. You have to do what's called, you have to be effective at what you do. Okay, so these were their training in this case. They had a very high rate of turnover. So they had 30% turnover every year. So the government's argument was, if you're doing a professional training once a year, then there's no way you're compliant, because at least 30% of your people didn't get trained for a year or more. Okay, so on the social media side, a lot of people do not appreciate, or a lot of medical professionals do not appreciate that patients are looking a lot more like consumers now. They go online, they do research. Okay, 88% of them do that. And actually, so the top 5 Yelp searches are actually medical: optometrists, dentists, general doctors, chiropractors, and acupuncturists. So if you go on that theme, continuing down that line, U.S. News World Report, how many people, in the end, what the point that I'm trying to make here is, often they are trusting more what they see online than when normally they would ask their friends. And even people that are happy with their doctor, still 55% of them will go and look you up and see what you look like online. So there's some very practical things that every medical practice, large, medium, small, should be doing. I'll talk about those at the end. Okay? So now, for those of you who are doubting, well, I think the folks on this call are probably not doubting Thomas's, but all of us, I'm sure, have somebody in healthcare that we've spoken to says, I don't have to worry about this, or I think what I'm doing is good enough. Well, if you ask your patients, in the end, we've not done a great job in healthcare. Okay? And so, for example, 68% of the people who asked are not confident at all. And of the people who have actually had identity theft, 53% of them say it was caused by a medical practitioner. And I call this my cocktail party or barbecue story. And often when I walk into a barbecue, people ask me what I do. When I say I'm in HIPAA compliance, I get story after story as to why they never went back to a doctor's office because of something that happened to them in the waiting room, while in the exam room, while walking through the hallway. They are sensitive to this. Okay, so you don't presume that they don't care. Now, one of the things, and what makes a patient loyal, I found this very interesting. I looked around for research from a lot of different places about what were the predictors of whether or not someone would stay loyal to you. Now, I think a doctor's office is very much like a brand, where we're talking about Starbucks, Disney, or Nordstrom. What is it that makes one want to stay with you? So there's your overall satisfaction. Was their experience good? Your reputation. That's the things you're talking about when I'm talking about online. Now you start getting a little more into the weeds. How did you deal with a problem? Okay, problems happen for everybody. But was your staff attentive, responsive? Okay, did they follow through on what they said they would do? Okay, did they feel as if their staff was treating you with dignity and respect? Okay, and if you think about it, when you're walking on the streets of Disney, or if you walk into, for example, a Starbucks, and if you were to say, listen, for those of us who like to pay a lot of extra money for our cups of coffee, why? In my case, it's consistency. I go anywhere in the country and get the same cup of coffee. So how do they do that? Okay? Whether we're talking about loyalty or we're talking about Starbucks now, they deliver the value in a consistent cup of coffee, is it starts off, they have written policies, procedures, and a standard of conduct. Okay? 2, there's someone around keeping an eye on that. All right? Now, what's considered effective for your organization might not be the same as mine. So be sensitive to a multi-location organization versus a single location with 5 employees. One, a simple staff meeting could be sufficient to communicate. The other might require much more extensive. So is there a line of communication? Hey, if I'm making a cup of coffee and something's wrong with the machine, I can raise my hand, flag somebody down, they're going to help me. Now on top of that, there's somebody monitoring and auditing to make sure that the cup of coffee is consistent, how long it was cooked for, or brewed for, etc. Now, a couple things on the serious side. If I don't, as a barrister, if I don't do it properly, there's going to be a disciplinary guideline, and I could probably lose my job. Last thing, it is if there is a problem, cup of coffee was cold and everyone was unhappy, you want to fix that quick. Now, what you're hearing me speak about, okay, in regards to, and I'm using Starbucks as a background, is what's called the 7 fundamental elements of an effective compliance program. This is actually the federal guidance by HHS, Health and Human Services, the people who oversee HIPAA, so that if you really want to understand, you want to have, or a lot of times people say, well, I think I'm doing sufficient. This is the backdrop. Okay, if you can say you're doing these 7 items in an effective way based on your size and scale, then you have what is the appropriate things that that an auditor, if you had an incident or breach, would want you to see. Okay, so now On the more boring side, from a HIPAA perspective, a lot of people, this is where the misunderstandings come in. The 7 elements is what an auditor will audit you on. But the law is made up of 3 components. The privacy rule, which is how you speak to your patients. Not allowed to scream across the waiting room. Making sure that you don't leave, folders from one patient, available in the exam room, but another patient might see it. The basics of how you communicate with your patients. The security rule is where the big misunderstandings occur. Okay? And that what happens is most of the time what people are thinking is security, IT, security risk assessment. That is correct, except that's only really 2 out of what is 6 required audits. The other audits have to do with your physical location and with your administrative and privacy protocols. Okay, so for example, there's fines I'll talk about where one organization lost the laptop, no repercussions. Another organization lost the laptop, got fined $2.7 million, was considered negligence. Now, breach notification rule, this did change. A lot of people don't understand that back there was a 2-year grace period and a change in the law that happened at the end of 2013. So now it is required all incidences be investigated, large or small, and if it's considered what's called meaningful, more than 500 people potentially affected, you must report it to the federal government, and there's a whole bunch of additional responsibilities you have. Okay, so you must report to your local news service. You must notify all people who were affected. Why this can be so telling is, it's not necessarily the laptop that was lost. The fact that you might have to physically notify 500 patients about it, or 1,000, or 1,500, or 5,000 for that matter. At the average cost of $250 per, that can get very expensive for the average practice, even if nobody was actually affected. But because it happened, you didn't have the proper protections in place. Now, as I get into this, one of the things I want to stress is, if you did do everything correctly, okay, you don't have a breach or incident, okay, because you can have a horrible thing happen, a laptop gets stolen, and the government will not fine you in any way, provided you can prove that you had the 7 fundamental elements of an effective compliance program. So, what most people I talk to across the country, they do what's on the left-hand side. They do security well. So they've done security risk assessments. Maybe they've done an asset and device audit, if you've heard that term mentioned. Okay? Usually they do a pretty good job on their security remediation. So that can be, they put in a new firewall, and maybe they did some upgrading on their computers. They got rid of old Windows machines, etc. And then often we see policies and procedures. Unfortunately, very often they are only about security or very limited in their nature. They're not properly reflecting the whole organization. So now, being HIPAA compliant, though, which is, if you notice the theme of this, is a differentiator. It's something you can use to engage with more clients, to retain the ones you have. If you did HIPAA correctly, there are 6 required audits. Okay, so the first thing that happens is you must do all 6, and you must do them every year. You must have a documented remediation plan. So that's not, we talked about it in a staff meeting. That is, we identified all our gaps. We've looked anywhere that there was, protected or personal health information that was being worked with, whether it's digital or physical. We've identified where our gaps are against the law, and we have a plan to fix it. Notice I said plan. Okay, obviously you should be fixing it. I'll share a story about one of our clients lost a laptop. They had 28 or 30 locations. They had done a great job of updating all of their locations, except for the last 3 or 4. They just hadn't gotten to it yet. Function of time and money. That's where the laptop got stolen. All right. Now, because they could prove that they had done their audits and they had a plan, they would call what's good faith effort. There was no fine or penalty for that. Now, I'll show you another in a few minutes. I'll show you another example where exact same scenario, but a $2.7 million fine for negligence. Now, so you have your remediation plans. Fix the things that are physical in nature. Encryption, backing up your software, locks on doors. The rest of it is going to be policies, procedures, and training. So you must have policies, procedures, and training for everything related to HIPAA. Most organizations also need to address fraud, waste, and abuse. Once you have those, the trick is every year you need your people. Well, 2 things need to happen. You need to prove that you reviewed them every year. It's called document and version control. Real simple and plain, old-fashioned, layman's terms. You made sure that nothing changed in your business or in the law that would have changed the nature that your policies or procedures needed to be modified. Now, another big area we think is very critical, and we see a lot of folks get in trouble, is just because you gave somebody an employee conduct manual, just because you had a staff meeting, doesn't mean that they understood it and they agreed to it. So having specific attestations, could be paper, yep, I read and understood this, or I saw this and understood it. Those are the kind of things you need to have. Last thing, in today's world, that rule change, it's called the omnibus rule, that changed in end of 2013, that it requires all of anybody who's working in any way for you where they could come across PHI. So that's could be your lawyer, could be your accountant, definitely your EHR, could be if you have a billing group you work with, IT firms that you work with, and in some cases insurance groups. So for example, like a self-insured group, they're looking at your patient's PHI. Okay, so you need to have what's called a business associate agreement, as well as do what's called a technical due diligence. One question that comes up a lot is a BA agreement is a good thing. It actually limits the liability of all parties involved. So if you get somebody pushing back saying they don't want to sign a BA, they can't take on the additional liability, they have not read it correctly. It actually limits their liability. The last thing you have to do is incident management. So you have to investigate anything that occurs where PHI was potentially affected. Depending on the size and scale of it, you got a different set of reporting requirements. But do not make the mistake of ignoring it. One of the first fines this year was a $475,000 fine for simply not reporting a bunch of lost paperwork. Okay, it turns out it was found later, unfortunately by somebody else. When they found it, they reported it as a HIPAA violation, and sure enough, it was a pretty big payout for that firm. Okay, so let's keep moving here. So the 6 required assessments: technical, physical, and administrative. That's where a lot of people get in trouble. The omnibus rule we talked a little bit about. The one thing I will stress on this is please do not blow this off. Okay, and one of the questions that I get almost every time I'm speaking is, yeah, but they're so and so. It's my cousin, it's my uncle. I trust them. I've been with this company for years. All of that is irrelevant. The law requires a physical agreement called a business associate agreement between you and anybody that you are in any way sharing PHI with. Okay, so do not make the mistake of, well, it was no big deal. They were doing billing work for me. They took it home, and I never expected this, because it happens. So, for those of you who think it doesn't happen to you, more than half, in this case, this is just business associates. I said 30% of the risks are the vendors that serve you. More than half the business associates had an incident in the last 2 years, and a meaningful incident, a serious security breach. You may have heard things like Blue Cross Blue Shield, Anthem. There are some very big players that really had good, strong plans in place that still had breaches. And I stress this because one of the many misunderstandings we hear is I don't have to worry about this because my IT company's taking care of this. I'm using an EHR and I have a HIPAA compliant hosting service. All those things are wonderful, but they're not necessarily protecting. So let me give you a couple of real world examples. So patient testimonials, you have patients, unless you have a specific letter saying that you have the right to put their testimonial up on your website, you have use and disclosure documents to be in the fancy thing. One organization, they did get permission. The client had given them a testimonial, but they never asked if it was okay to put it up on that website. 25,000. Press releases. There was one there was a Texas-based hospital caught somebody perpetrating fraud, waste, and abuse. They were very proud of having caught this criminal. Unfortunately, when they posted the procedure and the woman's name, she had a legitimate HIPAA breach and was able to ultimately point that out. $2.4 million fine. The late notification we talked about. Okay, let me slow down on this next one. The unencrypted devices. So I gave you the story before of one person who got no fine. Let me give you the person of someone who did have a fine. This organization, they lost a laptop. They were very proud of the fact that they had done 6 security risk assessments, one every year per HIPAA law, going back 6 years. They were very proud of their HIPAA compliant hosting service. It was an excellent one. They were also very proud of their EHR that they worked with, also HIPAA compliant. The reason why they were fined, though, is because the government auditor looked at it and said, if you had truly assessed all the risks of the way your operation ran, you would have known that your employees regularly take equipment off-site, And in this particular case, it's not that the laptop was stolen. It's not that the laptop was unencrypted. The issue is why was it in a child's hands while on vacation? Okay, there should have been, it was considered negligence. There should have been a policy that said, well, either you can't take it, or if you do, you're responsible for making sure it's locked in your hotel room or in your hands at all times. Okay, and that's the kind of, a lot of people, when I talk to them, they think the government is out to get them. They're not. What they are out to do is they do not like negligence. They don't like people not taking this seriously. So, you really do want to be thinking about this. I had one that I saw, which was a BA agreement one. Organization was having their X-rays. What do you call when you go recycled? Okay, but they didn't have a BA agreement with the recycling firm. That was also it was a $750,000 fine for that one. Okay, so all of these things add up. This is not a joke. A lot of people are like, yeah, they're not going to come after me. Yes, they will. All right. And now I've seen $4 million in fines in the last quarter just by state attorney generals. Do be aware that they do not have to just deal with the government. They are welcome to. They can actually go after you as well. All right, we're doing good. I'm trying to stay within my 20-minute mark. So HIPAA is good for business. One, it's a law. You got no choice. Two, if I were, just about every medical practice is concerned about how do you acquire more patients and specifically how do you retain them. Once you've got them, how much you bill per minute and, how much you bill a day, etc., is directly related to obviously how many patients you have that like you and are staying with you. So being HIPAA compliant, and we've done some studies where we've seen as much as 17% increase in conversion by having it clearly stated on your website that you take HIPAA compliance seriously. So it is a differentiator. We talked a little about whether you're going to use Starbucks as your brand example, or just think about your people talk about their doctors. You want them to be talking about not, I never went back there because I heard the nurse talking about your procedure in the other room. Okay, those are the kind of things you have to watch out for. For those of you who are doubting Thomas's, one of the most vivid examples I have of where HIPAA compliance is differentiator was Fitbit, the exercise device. They ran a press release in September of last year. When they ran the press release, all they did differently that day was say that they were HIPAA compliant. Their stock price went up 26%. So just in that day alone, it did come down a little bit a couple of days later. But just do understand, your people, the average consumer does know and does care. Okay. All right. So from a HIPAA perspective, you want to think of this as puzzle pieces. You want the whole thing to be addressed. You want to make sure you do all of your audits every year. Do not just do the security risk ones. You must do all 6. Make sure you have remediation plans that are documented. Not we had a meeting, we talked about it. No, we made a list of all our gaps. We captured that information. We're tracking what we're doing on how to fix it. That was the example of the firm. It got fine. Policies, procedures, and training. It's okay if you are getting them from an association, for example. Do make sure they accurately reflect your business. Do not just put this binder on a shelf. You will get in trouble for it. And it's also a great way from a branding perspective. Your policies and procedures are really the operational manual for your employees, so that they know what to do. When someone, if you know that all of us have different patients, difficult patients or difficult clients. It is much easier for your staff where there is a clear set of guidelines of what they're allowed to do and what they're not allowed to do. Okay, it takes all the question out of this. Okay, which improves. Remember that loyalty slide I told you about? The patients do care. They want to know you have a process for dealing with when things don't go well. Document version control, employee attestations. Do not just do big meetings. Make sure you have all that stuff documented. Business associate management. Those are BAs. Make sure you have them in place. And then if you have an incident, do the investigation. So a couple, I would say we can start taking questions now. Also, if you do, you are welcome to. It's totally free. There's no cash to this. There's a checklist we have on our website. You're not filling something out and giving it to us. You download a document, take a look at it. If you feel comfortable with the information you're looking at, you feel you have it properly addressed, you're in good shape. If you're not feeling comfortable or you're not confident in what you're doing, or even worse, you're like, yeah, we know we're not doing that, please, our pleasure to help you out. Give you some. By the way, you don't have to be a customer to ask questions. We're really excited when we have an opportunity like what we're doing today with Presidio to be able to talk through how education will hopefully help you. All right, so now hopefully everyone heard me. Giselle, I don't know if there are questions.
Yeah, Mark, a question on reporting a breach. So it looks like the 60 days that you have to report the breach, but take the example you gave of the laptop. Laptop they think is stolen, but it's recovered within that 60-day window. Do they still have to go back and report it as a breach? Or if it was recovered, can you then say, well, there wasn't a breach? What's the rule on it?
Well, okay. That is a fantastic question, actually. It's the first time I've had it asked quite that way. So an incident or a breach is an incident or a breach. If you fix it quickly, it still occurred. Okay? So if you had a lost laptop, and the reason why laptops are so dangerous is because maybe you don't have all the files on it, but most people's laptops, it's storing your passwords and your logins so that people can get to the information. Okay, so in that particular case, even though you recovered it in those 60 days, you would still be responsible for reporting it as an incident or breach. Now, understand that reporting an incident or breach is, this happened, we found it, we fixed the problem, therefore resolved, is a wonderful thing to say. Okay, the one exception, and only because you asked it, and you asked such a great question, I'll explain the one exception. Part of being HIPAA compliant in today's world is having all of your data encrypted. And without getting real techie and geeky on you, there's a lot of different ways to do that. Like many of the technology you're using today actually have encryption built into them. But if you can prove that the laptop that was stolen, that the data on it was encrypted, both at rest and in motion, don't worry about that technical term. People who have to worry about this for a living will tell you how to do that. If you can prove that you had everything encrypted, it's not a breach. And the reason being, nobody could use that information. Okay? There is no way, if you had a properly encrypted hard drive, that someone can open it and access the information on it. And in that case, it's not considered a breach because there was no access to anybody's information. So hopefully that was a great question. Thank you.
It does. And then Mark, another question is, let's just take, for example, obviously medical groups have so many different things that they have to worry to be in compliance, including HIPAA. Let's just take a, say 5 to 10 medical group practice somewhere in the West, and they want to make sure they've hit every piece of that puzzle that you showed. What would you estimate it's going to take in terms of both cost to the company and hours? And I emphasize hours because our administrators tend to say, look, I have so much to deal with that adding this to my plate, I think I'll just take the chance, going back to your shark attack file. Obviously, that's not a great one, but that's what we hear. And so the question is, can it be turfed to you or someone like you and say, here, Mark, you handle it? And if so, how much are they going to set aside in both human resources, time for the practice, and financial resources? What's it going to cost? And, I'm not sticking you to it. I'm just saying ballpark. For our groups.
Okay. So most organizations, the reason why this is so problematic for them is it does end up taking them a lot of time because it's not what they do every day, right? And because in most cases it's not a revenue generating event, it's the last thing on the list. Okay. Now, there are external solutions to help you with this. Right, so often people will get involved with a full consultant, a lawyer. There are some security assessment tools, sometimes provided by an IT person, or some are self-taught. The problem is, what we find is bringing a bunch of different pieces together cuts some time, okay, but it doesn't necessarily really ease the pain. And I apologize, this is not meant to be self-promoting. What we believe, okay, this is our belief as a Compliancy Group, is that what is the optimal solution is a combination of somebody who is experienced and you doing some of this yourself. That we think is the ideal way to do this. So you get the confidence of knowing you did it correctly, but you were involved, because what we have found is if you're not directly involved with understanding this or being a part of how an audit, if you want to call it, which is the term for it, you're never really going to appreciate why it's a bad idea to leave that folder out on the countertop. Okay, or why not shredding documents at the end of the day is a vulnerability. To more specifically cost and time, in our case, we consume usually about 20 to 30 hours of one person's time. We usually spread it out over 3 to 6 months, just so it's not too much of a burden. Cost-wise, for most average practices, and this is, I think, universal across all the different third parties, you will see some what I would call checklist-based solutions that are, could be $1,000 a year, $100 a month, right? To far more where a consultant or a lawyer is coming in and doing this for you. I mean, that can be $30,000, $40,000, $50,000 per session. In our case, for the average practice, less than 25 employees, it's a couple $100 a month. That includes everything.
Okay. All right. And then that's an interesting question, actually. If you have a business associate agreement with a third party and that third party has a breach and now you're informed about it, is there an obligation that you have to report it if it was not a breach within your confines of your business, but rather you are advised that a third party had one with which you had signed a business associate agreement?
That's a real good one. And some of this does depend. Okay, so the BA agreement, a good BA agreement is very clear. What happens on your side of the fence is your responsibility to notify. If it happens on my side of the fence, it's my responsibility to notify. Okay, but I would say from a good customer service perspective, if your patients were their PHI was stolen or violated and it was done by another party, I would check with your lawyer. Okay, check that BA agreement. But I think it is the right customer service thing to do to notify the URL, because nobody wants to find out after someone's opened up bought a new car in their name and defaulted on it. Oh yeah, you knew about it, but you didn't tell me. Okay, but the legal answer goes to the BA agreement.
Okay, and the obvious question there is, within some of the resources you included for us, is there a BA agreement template that you like, that you feel is pretty ironclad, or is that really more part of designing one that's custom to each business?
So OCR, Office of Civil Rights, that's the enforcement arm of HIPAA. If you go to ocr.gov, they actually have, it's not exactly a BA agreement, but it is a really good document that it says this is what the agreement has to have in it. Okay, and often it's not meant to replace your contract in between you and a vendor. It's meant to be very specific around the issues of protected health information and that whose responsibility is to do what. So that's the best place to get one. I mean, we have one built into our platform, but one of the places that you can definitely find it is at ocr.gov.
Okay.
And if you drop me an email, I can send it over. I don't know off the top of my head, but if you drop me an email, I'll send it to you.
Yeah, and we'll do the same. Actually, we'll go ahead and get one posted within our website and actually shoot it out to everyone as well. And then the last question here, Mark, and by the way, those of you who needed to check out because our time is way over, feel free to do so. So my one last question, the business associate agreements, how often do they need to be re-signed? Is that part of your annual audit, or can that be a sign and leave it?
Actually, it's a great question. Sorry, you really asked good questions today. The
Keeping on your toes,
agreement. So the BA agreement does not need to be signed every year. It needs to be reviewed every year to make sure the relationship didn't change. Okay, so if it was a vendor who did one thing for you this year and then next year you added a bunch of services, that might change the nature of the agreement. The real world example was a shredding firm that just did paper shredding. Several years later, they also started doing digital destruction, and therefore the BA agreement needed to be updated because of that. Okay, the nature of what they did changed. Okay. Now, everything else tied to HIPAA is an annual requirement. Audits, training, attestations, that's where most people misunderstand and think that the BA agreement has to be re-signed every year, because everything else in HIPAA is based on an annual review.
Okay, and then I lied. I have one more last question, and that is that, and this came from actually one of our clients that had an issue. They were a cosmetic surgery practice with a surgery center, and they had put up some pictures on their website, the before and after type pictures. And they didn't include full patient, obviously, profiles. You couldn't see the face, and they did put a first name but no last name. And apparently their lawyer then said no, that was still going to be a problem because they put a first name. It was a small area. People could kind of figure it out. Any rule of thumb on that in terms of what the government actually wants to see? Does HHS say you cannot use a first name, or what's the It's a question I get quite a bit with my aesthetics folks.
There are 18 elements of PHI, and they're considered, but the easiest way to think about it, don't make your brain crazy trying to memorize 18, anything that is considered identifiable. So a first name, a last name, initials, identification numbers, sometimes even things like an IP address off a website, being able to, are all considered identifying. On the picture side, actually, that's also been a very problematic area. I do a lot with eye care. And, if you took a picture of my eye, it's, some people have very distinct eyes. So, the request is zero it in, blur it out to the point where that anything that could be construed as identification is not there. But absolutely, like a first name, last name, that's as far as the government's concerned, you've identified who they were. Mm-hmm. The only flip I'll give you, especially people who are dealing with, say you mentioned cosmetic surgery, if the patient gives you permission to do it, then it's perfectly okay. I guess where a lot of people misunderstand, they think that HIPAA says no one can ever share anything personal. No, if I give you permission to put a picture of a procedure I had, put my full name and put my testimonial below it on your website, that's absolutely appropriate. My counsel would be to any one of your clients is make sure you get that in writing. If your patient says it's okay, so great. I'm sure your lawyer has one. If not, that gets built into many of the platforms. There may even be one on the HHS website, and that is a document that says, I've given you permission to put this information in the following. By the way, one thing I will advise you on this, when it comes to testimonials of this nature, be specific. I have permission to use it on my website, my Facebook page, my Twitter page, etc. Because it has been multiple times. I got permission to put it on my website, but then you post it in another medium. Patient felt violated, reported you. So be careful.
All right. Well, thank you, Mark. Really appreciate it. That was all really good information. And like I said, I'll be providing more resources like the ones that you included here. And I'm going to quickly let you know what's coming up next, which ties quite into what Mark's topics were. We'll be covering some social media, both a little bit on the risks, which includes some of this HIPAA stuff, but also it's today's marketing, right? And Mark touched on that, and we're going to touch on it a little bit next month. And then after that, we're going to talk a little bit about PCR pathogen testing, which is the new best, greatest way to identify certain pathogens. And we'll have a pretty interesting speaker. We'll get more info out to you on both of these very soon, and hope everybody has a great week and is enjoying the World Cup soccer. And Sam's going to laugh because I could not help but include World Cup pitch. Go Columbia Tuesday morning, 5 a.m. Pacific time. Have a great week, guys.
Thank you very much.